wish to offer you my sincere thanks. Thank you for your service these past 2 weeks. I realize what an inconvenience it can be to sit on the jury. And a trial like this, you've been here a little over 2 weeks. You've had to see over 100 exhibits passed, hours and hours of testimony, a lot of it tedious and laborious, some of it not so tedious and laborious. But we've kept you from your businesses and your families and inconvenienced you in 100 ways. I myself have never been called for jury duty, and as a trial lawyer, I doubt that I'll ever get the chance. But I agree with His Honor that jury service is one of the highest forms of public calling that a layperson can have, and we're grateful. Now, the past couple of days, as I was considering the kinds of things that we would talk about during my time up here, it dawned on me that we have another Memorial Day approaching. And that's a day for reflection. It's a day for celebration. It's a day that we give thanks to those people that answered their country's calling and took up arms and fell in the service of America. I can't say that it's a uniquely American holiday, because I'm sure plenty of countries have a similar celebration. But Memorial Day is an American tradition. We come together with our families. A lot of us have service people in our families that are no longer around. And we celebrate their lives, and we offer our gratitude. We come together as a country, as a nation, as a way of hanging our flag and having parades. And we, in some small way, recognize the sacrifice of those fallen heroes. As a nation, we've endured for about 2.5 centuries. Pretty close. We've endured as a country. Not many countries can say that. Not many countries make it that long. But we've endured. Not because we're particularly bright. Not because we have immense wealth. But we've endured because we're a nation of law. Above all, we, in America, are a nation of laws. So many years ago, people in this land pledged their lives and their fortunes to keep in place a system in this great country in which we can have a trial by jury. Because a lot of places you don't get that. And it was a struggle. And there were wars. And during that time, the great statesman William Penn, for whom we named the state of Pennsylvania, he was shanghaied, put in chains, and taken back to Britain. And he had to stand trial for treason. For treason against the king, we call it. For his struggle in making this country independent and the great country that it is. That trial was held before a jury, much like you in the box. But times were a little bit different back then in England. So when at the end of the trial, the jury said, "This man is innocent," well, the king directed the sheriff to round up all the jurors and put them in a dungeon and hold them there and not to let them out until they voted to convict. And they were held for months and months and months. And they refused to convict them. They won. Now, nothing like that's going to happen here. You 13 are a part of that historical line. Your jury service in some way carries on the tradition of the Founding Fathers and the jury system that so many people have fought for. In any criminal courtroom, the first commandment is the presumption of innocence. That's the pinnacle. That's where you start. And it carries with it strict rules concerning whose burden it is, who carries it, and how, if ever, it can be overcome. The second commandment of the courtroom is that standard proof beyond a reasonable doubt. No one in this land can have their liberty or property taken unless the prosecution proves beyond a reasonable doubt guilt beyond a reasonable doubt. That's a difficult concept. It's one we don't face much in our ordinary lives. You don't hear it very much outside of the courtroom. And it requires a diversion from ordinary thinking. The reason I say that, if you have a suspicion of guilt, that equals not guilty. If you find a possibility of guilt, that equals not guilty. Even if you find a high probability of guilt, that equals not guilty. Under the law and the instructions that Judge Coretti will give you, you cannot vote guilty upon a suspicion, upon a possibility, or upon a probability. A vote of guilty requires an abiding moral certainty of guilt, a certainty that transcends possibility. It transcends possibility, and it transcends speculation. Now, of course, there have been many instances, many trials, where a juror or a panel has left the courtroom having voted innocent, having voted not guilty, but thinking, maybe the person did commit the crime. And there ain't nothing wrong with that. Because in doing that, that juror has precisely carried out their oath and carried out their duty with precision and honor. Folks, that's the way it's supposed to be. That standard I talked about, beyond a reasonable doubt, is the highest standard of proof found in any court anywhere on the planet. And it's not just something we came up with willy-nilly. It's based on the principle of our society that it is far worse to convict an innocent person than it is to let a guilty person go free. So says our Supreme Court in Washington. Now, you'll get the instruction and you'll understand how, if at all, the prosecution can overcome that burden and what a reasonable doubt means. When I was training for my craft, I would sit and listen to trials, and I'd hear the older lawyers, and they would talk about things like a shadow of a doubt, or a moral certainty, or to reach an abiding conviction, all that beautiful language. It's lost today. We've adopted more common, more understandable, I understand, that's theory of language, and we use more common parlance. But though the words are different, the spirit remains. If there's anything about this case that's caused you any hesitation, that's given you pause for concern, I submit you found your reasonable doubt. I'm not going to walk through all the bits and pieces of testimony and evidence. I know you've been attentive, you've been taking notes. I've watched. I just want to give you some items to think about when you go back into that jury room. Let's focus on the important facts. detective told us her job was to track down all leads. Her words, not mine. Do you believe they did that? Do you believe they took Darcia Plant seriously when she testified seeing the stranger leave Ramsey Scrivo's apartment? Or did they just blow her off? Well, it must have been the unit next door. They now know it wasn't the unit next door. That unit was empty. Did they take Lori Krim seriously when she told police officers there was a suspicious stranger lurking about Mrs. Scrivo's house a few blocks away? No. They wrote it down and put it in a file somewhere and it got buried. And what about Ramsey himself? He told his friends. He told his neighbors. He sent text messages. Someone's after me. Someone's casing my house. Someone's been in my unit. They had that information. Did they really track down all the leads? They'd have you believe that Mrs. Scrivo made 3 trips to Lowe's to buy a saw when she had 3 power saws in her house. Why would she do that? Why would she risk, if she were the killer, which she isn't, why would she risk making those multiple trips in broad daylight? She never had to leave the house. The stuff was there. The nurse examined her body and took the scrapings and took the hair samples and found none of Ramsey's DNA anywhere on her. None of his blood anywhere on her. And they say, well, she took a bath and it all came off, so no wonder it's not there. Well, obviously, according to them, the nurse knew she had bathed. Yet the nurse didn't say, well, we can't do the test because you bathed, so there won't be any evidence, so go home. No, that's not so. And bathing does nothing. How on earth is this woman, 110 pounds, barely, how is she able to wrestle a 230 or 240 pound dead body into a bathroom? How? How could she do it? How? She couldn't. That's a rhetorical question. Don't answer. Impossible. Wouldn't happen. Couldn't happen. Dr. Spitz was on the stand for the better part of the day. And he had a lot of technical information, and he walked you through all the body parts and the chemical tests and this and that and the saw and blah. And then when we asked him toward the end of his testimony, I think this is his most telling part of his testimony when he said, Ramsey Scrivo was dismembered by one with no skills or knowledge. And I think that bears repeating. The dismemberment was done by somebody with no skills, with no knowledge. Does that fit the profile of a nurse with 30 years experience? 20 years of those years in a big city hospital? You don't think she knew basic anatomy? You don't think she knew how the bones and the sinew and the tissues are put together? That she would have to do and resort to such a hatchet job? I don't think so. No skills or knowledge. And finally, what reason on earth? Call it motive, call it cause, call it motivation. What reason on earth would this mother have for killing and mutilating her son in that fashion? Because of some picture on Facebook that she thought was a handsome person? Don't buy into that. That's not right. That's desperation. So they want you to believe she's a murderer. She dismembered her own child. And she did all these crazy things in broad daylight. Driving to the insurance office, driving to Lowe's, driving to the Secretary of State, driving to the police department. She would have to be the stupidest murderer ever in the world, in real life, in fiction, any place, any time. No one would be that stupid to behave in such a way unless she was forced. Unless she was directed at gunpoint to do these seemingly stupid things. We heard from a number of people that testified under oath as to her good, solid character. Unrefuted evidence of her beautiful, untarnished reputation. That she's a loving mother. That she's a devoted mother. That she's an adoring wife. And that she's a caring nurse. And why do you suppose those good people were attacked so viciously and tried to suffer the slings and arrows of the prosecution? When all they did was come to court to say what they know. Why did they have bloody saws dumped in their laps? I wonder why. I don't know. I wonder. You know, in most court cases, we're not even allowed to bring in character evidence or character witnesses at all. But in these cases, the law allows it. And that's a reflection of the humanity of the law, based on centuries of human experience. And in a few moments, Judge Coretti will tell you this. Evidence of good character alone may sometimes create a reasonable doubt in your minds and lead you to find the defendant not guilty. My time is basically up. I'm done talking. I have no power to affect the outcome of this case or to steer the fate of Donna Scrivo. That power lies with you guys. You have the power to find the doubts, to examine these questions, to examine the evidence critically, to examine the exhibits critically. You have the power to go back in there and deliberate, and to march back in here and look all of us in the eye and say, no, we are not convinced beyond a reasonable doubt. We are not convicting Mrs. Scrivo. Thank you.
Mr. Haddad speaks of humanity towards the law. I think this case is really more about inhumanity of man towards man, or of mother towards son. This is a cold-blooded murder by a mother of her son. I also found it interesting that he completely ignored her 2 days worth of testimony. I've proven my case beyond a reasonable doubt. I would ask you to find her guilty on all counts. Thank you.
All right, ladies and gentlemen, retire to the jury and do not take the jury.
All rise to the jury, please.
All right, you may be seated. We have another short recess. Ready, Your Honor.